Welcome to AutoNoFaultLaw.com and to the utilization review pages. My name is Katie Tucker and I'm an attorney at the Lansing office of the Sinas Dramis Law Firm. I focus my practice on representing injured persons and their medical providers in pursuing and recovering claims for no-fault benefits. I'm here with you to talk about the new DIFS utilization review process, which will affect medical providers and patients alike, and more specifically to talk to you about the three distinct stages of the process that are governed by the new DIFS utilization review rules. And with that, I'd like to share a PowerPoint presentation that I've prepared on utilization review. And the utilization review process, which again consists of three sort of separate stages: the request for explanation stage, the insurer determination stage, and the appeal stage. Importantly, utilization review and the utilization review process only involves medical providers, insurance companies, or the Michigan Catastrophic Claims Association and DIFS. There is no direct role for a patient or an injured person in DIFS utilization review process. But let's get started with understanding the first stage of that process, which involves record acquisition and request for explanation. Under the new utilization review rules, which you can find on our website on ANFL.com, and which I encourage you to read, an insurer or the Michigan Catastrophic Claims Association may request that a medical provider explain the necessity, need, or indication for treatment in writing if the treatment falls into any one of these four categories. Either that it's not usually associated with treatment that would usually be required, it's longer in duration than, more frequent than, or extends over a greater number of days than the treatment which is usually required. Notably, the rules themselves do not define what constitutes what is usually required, but because of the definition of utilization review, which is set forth in the statute and the reference to medically accepted standards, which are defined by the rules, I anticipate that we'll see DIFS and potentially courts interpret this phrase usually required to be consistent with the definition of medically accepted standards. So if an insurer, the MCCA, determines that a provider's care falls into any one of these four categories, they may request the provider to explain the need for that care in writing. And as part of that request for explanation, the insurer, the MCCA, may also request that a provider include any one of these three categories of information or documentation: medical records, bills, or this very broad catch-all category, other information concerning the treatment. I certainly expect that we will see requests from insurers of the MCCA that providers supply information about the patient's medical history, other care perhaps that they've received, and potentially a whole host of other information. So this is a very broad catch-all category. The rules also set forth very specific timelines for complying with requests and for submitting requests. So, and it's important that providers and insurers adhere to the timeline set forth under the rules. So for example, if a provider submits a bill to an insurer on January 1st, 2021, within 30 days of receipt of that bill, the insurer's request for explanation must be submitted to the provider. And very importantly for medical providers in Michigan, within 30 days of receipt of the insurer's request for written explanation, a provider's response would be due. Within 30 days also of the insurer's request, the insurer, under the new rules, has the obligation to reimburse the provider for its reasonable and customary fee, plus the actual cost of copying and mailing any records that are requested by the insurer, the MCCA. So the provider does have the opportunity to recoup costs associated with responding to insurer's request. And in fact, it's our recommendation that they do so by tracking any time, administrative or other time that's spent in gathering and compiling and remitting information requested by an insurance company or the MCCA, and sending an invoice and with a very simple cover letter requesting reimbursement. So the first stage of the DIFS utilization review process relates to these requests for information and the supply of that information by the providers. What happens after a provider submits the information that the insurer has requested? Well, at that point, the insurer or the MCCA may determine one of two things, and this leads to the second phase or second stage of the UR process. The insurer or the MCCA may determine either or both that the provider overutilized or otherwise rendered or ordered inappropriate treatment, training, products, services, or accommodations, or that the cost of that treatment was inappropriate. And the authority for making this determination comes both from the rules themselves, Rule 64 sub 1, as well as from the statute itself, Section 3157A5. And under both the rules and the statute, the no-fault law, an insurer or the MCCA has the authority to make this initial determination about whether, again, the treatment is appropriate or the cost of the treatment is appropriate. And for those who are familiar with our no-fault system and the no-fault law, you'll recognize these two inquiries as being very closely akin to the reasonable charge requirement and the reasonable necessity requirement set forth under Section 31071A of the no-fault statute. Again, the rules refer to the appropriateness of the cost or the treatment, while the statute refers to the reasonableness of the care or the charge. But I anticipate that we'll see DIFs apply this standard, this appropriate standard, in much the same way that the reasonableness standard is applied in terms of charge and necessity under Section 31071A. How does an insurer make this determination? Well, they must issue a written notice. And the written notice must be supplied to a provider within 30 days of receipt of the provider's written explanation. Now, the notice must include several pieces of information, all of which are explicitly set forth in Rule 64 sub 1. Again, many of these things are going to be familiar to those operating in the no-fault system as things that are commonly found right now: an explanation of benefit statements or explanation of review statements from a medical review organization or a third-party auditor. These things are the criteria or standards in which the insurer relied, with specific reference to the utilization review program, the amount of payment to the provider, a description of any additional records the provider must submit, and then two additional things that are also brand new: a copy of the appeal form referenced in Rule 65, which we'll talk a little bit more about in just a moment. And that appeal form is also available on ANFL's website, as well as the date of the determination. And this date is very significant because it triggers the provider's timeline for filing an appeal with DIFs if it so chooses. So if a provider wants to pursue an appeal through DIFs, the date of the determination is going to be very significant. Now, as I mentioned a moment ago, one of the things that must be included on the insurer or the MCCA's written notice of determination, which is provided to the medical provider, are the criteria or standards on which the insurer relied, with specific reference to its utilization review program. Under the rules, all no-fault insurers were responsible for having a utilization review program in effect, in place for review by DIFs as of February 16, 2021. Importantly, though, under Rule 64 sub 2, the criteria or standards on which the insurer relies in making its initial determination can simply be the determination by the Michigan Catastrophic Claims Association. So if you're a medical provider and you receive a written notice of determination, you may see language that indicates that the criteria or standards on which the insurer relied in making that determination are in fact the MCCA's determination on the issue. After the insurer or the MCCA makes its initial determination, what does a provider who is aggrieved by that determination or disagrees with the determination, more specifically, what happens if the insurer or the MCCA denies payment? What recourse does a provider have? Well, one possible course of recourse, one possible avenue, is to pursue an appeal through DIFs. There is another potential avenue of recourse, which is to file a lawsuit and exercise the direct right of action provided to medical providers in Michigan under Section 3112 of the amended version of the statute. But within the context of the utilization review process, which we're talking about as part of this presentation, a provider may, but is not required to, appeal an initial determination made by an insurer in the MCCA, most likely a denial of benefits to DIFs on a form prescribed by DIFs. If a provider elects to pursue an appeal through DIFs, all of which again is part of stage 3 of the UR process, DIFs shall notify the insurer or the MCCA and the injured person and the patient or the claimant of the provider's appeal. And that notification will be sent within 14 days of the provider's appeal. After receiving notice, the insurer, the MCCA, may file a reply to that appeal within a prescribed time frame, which we're going to review in just a moment. And once the insurer, the MCCA, files its reply, the DIFs director has a certain time frame, again, which we'll review in just a moment, to issue a decision. Importantly, the DIFs director's decision is based solely and exclusively on the written material submitted by the parties. So as part of this appeal process, stage 3 of the UR process, there is no contested hearing. There is no opportunity to present witnesses or an oral argument to DIFs, to engage in motion practice or discovery or any of the other aspects of a civil case litigated in a Michigan trial court. Instead, the DIFs director shall make, in this case, her decision based solely on the written material submitted by the parties. And this is why, and we'll review this in just a moment, it's so critical for medical providers who wish to appeal to DIFs a decision made by or determination made by an insurer, the MCCA, that they take the necessary time to gather all of the relevant documentation and to submit a thorough and complete appeal form to DIFs that gives them the best possible opportunity to have their particular claim reviewed and a decision to ultimately issue in their favor. If DIFs does rule in favor of the provider, a provider may be entitled to Section 3142 penalty interest on any overdue payments. And for those who are familiar with our no-fault scheme, this penalty interest is also available in a civil action, again, in a lawsuit filed in a Michigan trial court. The DIF's decision is ultimately and importantly also subject to judicial review as provided in Section 244 sub 1 of the Michigan Insurance Code. So if ultimately DIFs does not issue a decision in favor of the provider and the provider wishes to essentially appeal the DIF's decision on appeal, it may seek and do so through judicial review, although exactly what that judicial review will look like remains to be seen. And I think it will be the subject of some litigation and potentially appeals in the months and years to come. It's not clear at this point whether judicial review would include, for example, a jury trial or an opportunity to present witnesses or engage in motion practice or discovery practice at the trial court level. Or whether instead it would be limited to a judge's review of the administrative record below. So that remains to be seen. But what is clear from the rules themselves, and specifically from Rule 65.7, is that the DIF's decision is in fact subject to judicial review. How does a provider who wishes to pursue an appeal through DIFs do so? Well, they must submit an appeal within 90 days of the disputed determination. Recall that I mentioned that written notice of determination, that it's very important that providers track the date of the determination, because you only, as a medical provider in Michigan, you only have 90 days from the date of that determination to file your appeal form with DIFs. And if you do elect to pursue an appeal through DIFs and to fill out and complete that form, you should submit it either by email to this address or by fax to this number, both of which are also identified on the appeal form itself. And I'm sharing with you the first page of that form. We'll turn to our next screen and you can see both pages of this 2-page form. The form is called No Fault Utilization Review Provider Appeal Request. As you can see, there are several categories of information that a provider must supply in order to complete the form, including the date of the insurer determination, what we just mentioned a moment ago, as well as information about the provider, its NPI, its address, the claim number at issue, as well as contact information for the provider and basic information about the claim, like the date of the accident. In addition, the provider must supply, as part of this form, contact information for the insurer at issue or the Michigan Catastrophic Claims Association, and contact information for the injured person. And remember that DIFS has the obligation to notify both the insurer or the MCCA and the injured person of the provider's appeal. So I think that part of the reason that this information must be supplied on that form is so that DIFS can comply with its obligation to notify the appropriate parties of the appeal. In addition, there's this third broad category of information on appeal issues. There are several items that are required to be provided and other items that are optional, and we'll review those on the next screen. But the information on appeal issue category is the place and best avenue for a provider to supply all of the pertinent, relevant information that supports its position and makes it more likely that DIFS will rule ultimately in its favor in perhaps reversing or overturning the initial determination of the insurer or the MCCA. Finally, the provider must also certify that all the information that's been supplied is accurate. And actually an authorized individual must sign this form on behalf of the provider as an official acknowledgement of the contents of the form, as well as providing contact information. So what items should be attached to this appeal form, this 2-page appeal form, and what items are part of that third category that we just looked at? Well, what is required is a detailed statement of the reasons for the request for the review. And this is actually the best opportunity for the provider to really put its best foot forward and to explain its position and give any and all pertinent information that may lead DIFS to rule in its favor. So this is a really important opportunity for the provider to present essentially its case to DIFS. In addition, what is also required as part of this 2-page appeal form is that the provider supply a copy of the notice of determination, that written notice of determination, and or a denial of the provider's bill under Rule 64 sub 3. So if there is no official written notice of determination that you've received, you can also satisfy this form requirement by supplying any sort of documentation that your bill has been denied if you're a medical provider. Those are the only 2 items that are required to be attached to the form. However, there are a few items that are specifically identified on the form and that a provider can supply. First, all documents related to requests for explanation, exchange between the provider and the insurer prior to the appeal, any of the documentation that was submitted as part of that written request for explanation that we discussed earlier, as well as any pertinent clinical information, or again, this broad catch-all category of other supporting documents. And this language allows a provider to really supply anything that they think might be relevant to DIFS for its consideration, and depending on the particular facts and circumstances of the case and the claim and the denial, this will look different in almost every single case. But this, importantly, is the opportunity for the provider to really take a look at the file and the claim and the denial, and to supply DIFS with whatever may lead DIFS to ultimately issue a decision in its favor. So this is very important to complete this form thoroughly, deliberately, and to spend the time needed to make sure that the case is presented to DIFS in as persuasive a way as possible. What, again, is that timeline? Well, I mentioned a few moments ago that the provider has 90 days from the date of the determination to pursue an appeal with DIFS and to complete that form and to supply all of that documentation. Within 14 days of receipt of the provider's appeal, as I mentioned a few moments ago, DIFS must notify both the insurer and the patient of the appeal, and also request any additional information that may be relevant for its consideration from the provider or from the insurer. Within 21 days of that notification, the insurer or the MCCA may file a reply to a provider's appeal. And then within 28 days after the insurer or the association file a reply, the DIFS director shall issue a decision unless written notice is provided to all parties that an additional 28 days are necessary, in which case the DIFS director may actually have a total of 56 days to issue a written decision as to the merits of the insurer, the MCCA's initial determination. So from the date that the provider submits the bill, which recall in my earlier slide, we use as an example January 1st, 2021, until the date that DIFS is ultimately responsible for issuing a written decision. It's actually a 9-month span of time. So January 1st, 2021, potentially under this example, all the way to September 30th, 2021. So although in some cases, this may be a more expedient process than pursuing a civil lawsuit, it is certainly still a lengthy process and one that will certainly take several months. And I've prepared a document summarizing all the applicable timelines under DIF's new utilization reviews, including those which apply to providers, those which apply to insurers, the MCCA, and those which apply to DIFs, and the applicable rules and the events which must occur on each of the relevant dates. And this document is available on our ANFL website, and I encourage you to check it out and take a look at it, and hopefully it will serve as a handy resource for you. I hope this information has been helpful. Again, I wanted to give you an overview of the DIF's utilization review process in the 3 stages. If you have additional questions, please do not hesitate to reach out to the ANFL editorial board, and I encourage you to check out our other related pages on the site for more information about utilization review. Thank you.